Well, welcome everybody. Thank you once again for joining us today, and welcome to those who are joining us also for the first time. As ever, I ought to remind you that this session will be recorded. We'll be very happy to take your questions at the end of this seminar. If that point, if anybody wants to ask any questions, you can raise your hand. Alternatively, do feel free to email either me or Rupert or Shanna with any questions that might come up during the course of the seminar, and we'll try and deal with as many as we can at the end of the seminar. This is going to be our third talk about recent developments in DIFC law, and today we're going to be covering the topic of arbitration. I was just saying we will try not to stray too far into the last two talks, which were on jurisdiction and also on conduct enforcement in the JJC. But if you did miss those talks, there are recordings of them available, and we'd be delighted if you pick them up. There should be some links on websites at my chambers, 24 Old Buildings, and also Rupert's at Searle Court. And there will be two more talks after this. Rupert will be joining me for all of these. I think most of you will know both of us by now, but many of you will also know that we spend much of our time in Dubai dealing with disputes. We actually practice from different chambers in London, and we've come together to produce a new book on DIFC law and procedure. And it's going to have, as I explained previously, an expanded and updated commentary on the rules with discussion of the cases relevant to each part of the rules. And then in a separate section, there's going to be an extensive commentary on various aspects of DIFC law, including on today's topic, which is arbitration. And the book will be out in, I think, 10 days from today. So hopefully you'll feel like it's a worthwhile project, and you'll be able to support us with that. And hopefully we'll be able to get to a second edition. I haven't told Rupert about this yet, but I've got big plans for the next one. So today's topic is arbitration, and we are joined today by the author of that section of the book, who is Gregor Hogan. He is a barrister, also at Searle Court in London, and he practices in commercial litigation and arbitration, but he also deals with chancery disputes, including trust disputes, company law, and insolvency. And in a former life, he was a lecturer in constitutional and administrative law at Oxford University. So his knowledge of the law is deep and wide. So I shall hand over to him to introduce today's topic.
Thanks, Hall. I'm just going to enter my screen with some slides. So hopefully this will work smoothly. Hopefully that's working just straight if it's not. As Tom said, I'm going to cover arbitration today, and just to give you an overview of what I'm going to cover. First, we're going to look at some introductory matters, looking at some of the international regulations in this field. Then look at the scope of the arbitration law. Then turning on to looking at the court's powers under the arbitration law, in particular interim measures, and finally looking at challenging awards and issues in enforcement. So without further ado, looking at the sort of international framework within which the DIFC's arbitration law sits. Well, when we refer to the arbitration law, we're referring to the DIFC law number 1 of 2008 as amended by the first law of 2013. Unlike many other areas of DIFC law, the arbitration law is not based on the English Arbitration Act of 1996. Rather, it's based on the UNCITRAL Model Law on International Commercial Arbitration of 1985, although there are some important differences which we'll touch on during the course of this discussion. Another important international regulation in this area is the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, to which the UAE is a signatory. As we'll come to see, each of those international regimes has proved in its own way to be an important source of law for the interpretation and development of the arbitration law and the court's understanding of the DIFC's public policy in respect of international arbitration. So having cleared the ground, the first substantive topic we're going to cover today is the scope of the arbitration law. In determining the proper scope of the arbitration law, and by that I mean the reach of the arbitration law, the general rule is set out in Article 7, which provides that the law shall apply where the seat of arbitration is in the DIFC. There is an extension, however, of certain provisions in the arbitration law to non-DIFC seated arbitrations, and I've highlighted those on the slide. I'll draw your attention in particular to Article 13, which is the provision of the arbitration law which requires DIFC courts to stay proceedings before them where there is an arbitration agreement, unless the DIFC court determines that the agreement is null and void, inoperative, or incapable of being performed. Indeed, Article 13 is extended by Article 7 to situations where no seat of arbitration has been designated or even determined. That provision was introduced by amendment in 2013 after criticism that without it, the DIFC was not giving effect to the UAE's obligations under Article 2, Sub-Rule 3 of the New York Convention. You'll note that one of the provisions that's not extended by Article 7 to non-DIFC seated arbitrations is Article 24.3 on interim measures, and we'll come to discuss that later on in the seminar. An interesting question that's arisen is with regard to the schedule to the arbitration law, which is extended by Article 7. This has given rise to interesting questions about the extent to which the substantive provisions that are referred to in the schedule are thereby incorporated within the extensions in Article 7. The DIFC Court of Appeal considered this in Gray and Gibson Dunn, where the argument was that the provisions of Article 12.2, which set out the circumstances in which arbitration agreements and employment contracts are enforceable, was extended to non-DIFC seated arbitrations by cross-reference. The Court of Appeal rejected that argument, holding that the schedule did not incorporate cross-reference substantive provisions by the back door. The schedule, insofar as it was relevant, the schedule only extended the provisions on interpretation, time periods, and definition. So the core question therefore becomes, what is the seat of arbitration? Well, the arbitration law itself defines the seat as the juridical seat, which indicates the procedural law chosen by the parties to govern their dispute. Where there is a default, there is, however, a default DIFC seat, where the dispute is found to be governed by DIFC substantive law and the parties have not otherwise designated their seat. So the choice of law issues that have been covered elsewhere and are covered in the book can therefore take on a very special significance in the determination of the arbitral seat. Otherwise, the question really descends into one of contractual construction, and that was confirmed by the decision in 2009 of Deputy Chief Justice Wang in Deer and Waterfront Property Investment Limited. And this has left the DIFC courts grappling with various forms of contractual wording, such as disputes being governed by the laws of Dubai, the laws of the UAE, or being subject to the rules of the DIFC LCIA, in determining whether or not the arbitral seat is in fact the DIFC. It will be immediately clear to everyone in the seminar that these sorts of issues will also arise in the arena of jurisdiction clauses, where the parties who seek to opt into the DIFC court's jurisdiction under Article 5A2 of the JAL. I think it's fair to say that the early cases on arbitration clauses displayed a somewhat cautious approach on the DIFC court's part. So, for example, in the Deer case in 2009, the Deputy Chief Justice held that an agreement governed, quote, by the laws of the Emirate of Dubai, that had a provision that the arbitration should be conducted under DIFC LCI rules, and that, quote, the arbitration shall take place in the Emirate of Dubai, were all properly interpreted as giving rise to an arbitral seat in onshore Dubai. The judge noted that the phrase Emirate of Dubai was, quote, not synonymous or interchangeable with the DIFC, and he also said that if parties wanted an arbitral seat in the DIFC, they should go ahead and expressly choose it. Now, since then, and I think this is a viewpoint that Rupert and Tom agree with, I think it's fair to say that the DIFC court's approach has shifted to perhaps a more liberal and pro-DIFC approach to interpretation. So in the 2015 Court of Appeal decision in IGPL, the court held that the words UAE and Dubai could include a reference to the DIFC. The phrase Dubai courts was interpreted to mean DIFC courts, and courts of the UAE was not limited to the UAE federal judiciary. In the same year, the Court of First Instance in Gavin and Gaynor held that the phrase the courts in Dubai, the UAE, would be properly interpreted as the DIFC courts. And perhaps in a high watermark in the 2016 decision of Brookfield Multiplex, Justice Sir Jeremy Cook, albeit in obiter comments, had to interpret the clause that any dispute was, quote, to be submitted to arbitration in the Emirate of Dubai. He held that it did not matter that the agreement had been concluded before the DIFC courts were even established, that the seat had to be determined at the time of the dispute arose, and because one of the parties was a DIFC authority, such that, save for the arbitration agreement, the DIFC courts would have exclusive jurisdiction, it was, he said, distinctly implausible that the arbitral seat would have been disaggregated from the underlying law. Therefore, it's my view that there's been a clear progression in the recent cases before the DIFC courts in favour of finding the arbitral seat is the DIFC, even where the wording is suboptimal and generic in terms of reference to Dubai or the UAE. This can also be seen in the fact that in the DIFC courts, it's been recognised that a choice of seat can be an implied one, even where the clause is, quote, ambiguous and uncertain, and the court recognised that the entire contract made no reference to the DIFC courts at all. That was the decision in Gavin and Gaynor. There, the court relied on the so-called coffee shop jurisdiction in order to empower it to then interpret the clause in question to find an implied choice of a seat. And in fact, that case is interesting because the court had actually found that DIFC law applied to the substantive dispute, and so could have relied upon the default provision I mentioned earlier, but still went ahead and found an implied choice of seat. And indeed, in the recent decision earlier this year of Justice Shamlan in Limeo Investments, he held that the phrase, quote, any dispute shall be finally settled in accordance with the rules of the London Court of International Arbitration. The arbitration shall take place in the LCIA Arbitration Centre in Dubai, the UAE, properly referred to the DIFC LCIA rules as opposed to the London LCIA rules, even though the agreement had been entered into before the relaunch of the DIFC LCIA. Despite that, I would just draw attention to two important limitations. The first one is that, unlike in the case of jurisdiction clauses, the DIFC courts have made clear in the IPGL case that you cannot have more than one arbitral seat. We'll come on later on to discuss the distinction between the court's supervisory and supportive jurisdictions and how important that distinction is. And so I think that must be a decision which is right in principle. Secondly, one shouldn't overplay the relationship or the link between the DIFC and the LCIA and the DIFC seat. The courts have made clear, for example, in Deere, that there's nothing intrinsically incoherent between picking the DIFC LCIA rules for an arbitration, but say an onshore Dubai seat. And once that's accepted, in my view, it's logical that picking the DIFC as the arbitral seat cannot automatically mean or imply a choice of the DIFC LCIA rules. And indeed, the recent Limeo decision I just mentioned is a good example of that. So,
thank you very much, Gregor. I should say, Gregor, that I wasn't able to see your slide. I think you had one, but if we can't get that up on the feed, then what we'll do is we'll try and add it to the recording at the end.
Yes.
Thank you very much. Really helpful, interesting. Rupert, can I ask you a question that kind of follows on from this? You've seen the warning, in a sense, that Justice Wang gave in the Deere case. In essence, he was sort of saying, well, if you want to designate the DIFC as the seat, you really have to say the word DIFC. But then you've seen the more recent decisions, particularly those of Justice Jeremy Cook in the Brookfield case and in the Hayrie case. And so I suppose the question arises, is it right? Is Justice Wang right when he says that if you want to designate the DIFC as the seat, you really should be saying DIFC?
Thanks, Tom. Of course, he's right in one sense. If you want the DIFC, you should specify the DIFC. My beef, if you like, with the decision in Deere is that it's had a rather pernicious effect in that it's constantly cited in arguing that Dubai seat means onshore Dubai seat, because if the parties had meant DIFC, then pursuant to the advice given by the Deputy Chief Justice, they would have specified the DIFC. And you usually see reference to the DIFC notes to the recommended arbitration clause, which make the same point. Ultimately, and I should say that issue tends to detract from the real issue, which, as Gregor mentioned, should be an issue of construction, triangulation, looking at the applicable law, which are the procedural, the institutional rules that are applied. And the DIFC court has, to be fair, taken a much more mature approach recently in looking at all of the factors in seeking to construe what is the intended seat. I should just say, as someone who sits occasionally, that it's really important, if you're going to be arguing for a DIFC seat, to be making that case strongly from the outset, by reference in my suggestion to the DIFC cases and even the DIFC cases on courts of Dubai. Many external arbitrators coming from outside the region tend to assume that there's the DIFC and there's Dubai. They don't necessarily appreciate the more nuanced position that people in the region have, that Dubai can incorporate the DIFC. So it's important in terms of legal culture to take the tribunal to those cases, or the court to those cases, showing that seat in Dubai, or indeed the courts of Dubai, can be a DIFC seat and can be the DIFC court. I think DIA is a reflection of the timidity, a rather timid reflection of the early days, the insistence, if you like, on Article 7, which really limits the statute to domestic arbitrations. It's only in respect of recognition and enforcement that the statute is extended to foreign arbitrations. And so I think I'm probably kicking off an early campaign to ditch DIA at the first opportunity. I know we've got the workarounds we've discussed before, the winter cap jurisdiction, which is a workaround by reference to Article 32 of the court law. I know there's a lot of talk about the supportive jurisdiction as another workaround, again by reference to Article 32 of the court law. But I do hope that when these cases and when the winter cap jurisdiction eventually gets to the Court of Appeal, the Court of Appeal takes the opportunity to sweep away DIA and all of its negative influence.
Well, I think that's right. And I think the point that you make is right, that that there is a more nuanced approach to take than the one that appears really in DIA, and that ultimately it's a question of contractual interpretation. And so a blunt rule, like the way it's expressed in DIA, is perhaps not helpful. And I also agree with you that it is routinely rolled out by those who would seek to say that the DIFC court doesn't have jurisdiction because it's not a DIFC seated arbitration, or simply those trying to extend the process. But I mean, my experience in front of judges, and not a lot of these decisions get reported, unfortunately, but my experience in front of judges is that the judges are very receptive to these more nuanced arguments, and they don't get stuck on those passages in DIA, and they tend to get rather explained away. So I tend to agree with you, I think, Rupert, but I would also say that, I mean, my sense is that much of the current judiciary, at least, that I've appeared in front of, at least, appears to take that more nuanced approach as well. But as you say, there are potential other workarounds, so it may not be the end of your application for interim relief, that you can't show or can't persuade the judge that in this particular case it's a DIFC seated arbitration. And I think that Gregor is now going to come on and deal with some of the ways in which the DIFC court can assist in those sorts of circumstances.
Yes, exactly. I think I'm going to maybe perhaps abandon my slides because it is a bit strange though, because I can't see you when I have them up. But as you say, we can circulate them at the end. As I already mentioned, Article 24.3 of the arbitration law is not extended by Article 7 to non-DIFC seated arbitrations. Article 24.3 provides, and I quote, that the DIFC court shall have the same power of issuing an interim measure in relation to arbitration proceedings, irrespective of whether their place is in the DIFC, as it has in relation to proceedings in courts. The DIFC court shall exercise such power in accordance with its own procedures. First glance, that provision would seem to suggest that there is a power for the DIFC courts to grant interim relief in respect of and in support of foreign arbitrations. Indeed, in the UNCITRAL model law, the word place is used to mean seat, and given that the arbitration law is based on the UNCITRAL model law, that would, in my view, give further support, at least in principle, to an argument that the court does have interim relief powers for non-DIFC seated arbitrations. As our preceding discussion has shown, however, the first and most crucial question in any arbitration case involving the DIFC court is what is the proper seat of the arbitration, and that is the term that is used throughout the arbitration law and is the term used in Article 7 to determine the true scope of the arbitration law. This led Deputy Chief Justice Huang in DIA again to hold that Article 24.3 had been deliberately drafted by referring to seat to refer to the physical place of arbitration as opposed to juridical seat. And that case has become authority for a lack of jurisdiction of the DIFC courts to grant interim relief in foreign arbitrations, at least in respect of its powers under the arbitration law. And we should, of course, bear in mind that when the arbitration law was amended in 2013, the legislature did not choose to amend Article 7 to include Article 24.3 or amend Article 24.3 itself to refer to seat rather than place. And one might say that that reflects an underlying policy decision. As is often the case in the DIFC, however, as everyone's aware, parties in the courts have tentatively and progressively pushed at the limits of the Deere decision and the court's underlying jurisdiction to grant interim relief powers, and whether under the arbitration law itself or whether under the court's other sources of jurisdiction. So in 2016, in the Brookfield case I mentioned earlier, Justice Sir Jeremy Cook, whilst accepting the reasoning in Deere, relied on the UK Supreme Court's 2013 decision in AES Just to find that where the DIFC courts have jurisdiction over the parties in any event, Article 32 of the court law empowered the court to grant an anti-suit injunction in support of arbitration outside the DIFC. In quick succession, however, in 2017, in Maidan and Dayak, the court was not willing to grant an anti-arbitration injunction in respect of an arbitration seated in onshore Dubai. As many participants will be aware, the background to that case was unusual in that the DIFC court had already held that the arbitral tribunal in Dubai had been invalidly constituted by Dayak, but Dayak had proceeded in any event to go ahead with the arbitration, and in the words of the court, effectively ignoring the decision of the DIFC court. The case is also instructive on the issue of arbitrators' liability, which we cover elsewhere in the book. But what's particularly interesting about these twin cases is that they were decided not only very quickly after each other, but in fact by the same judge, Justice Sir Jeremy Cook. And in the Maidan case, he held that the powers of the court were expressly limited to those in Article 7.2 vis-a-vis non-DIFC arbitrations, and Article 10 of the arbitration law expressly prohibits any intervention by the DIFC court beyond those powers. Now, in my view, one way of reconciling these two apparently conflicting judgments is to consider the role the court was being asked to play. In the Brookfield case, the court was being asked to enforce only a negative right, i.e. the right not to be sued other than in arbitration. The court, therefore, was simply upholding the parties' bargain and supporting the arbitral process outside the DIFC. In contrast, in Maidan, the court was being asked to interfere by frustrating an ongoing, albeit invalidly constituted, arbitration in onshore Dubai. To grant an anti-arbitration injunction in respect of an arbitration in the proper seat cannot, in my view, be described as supportive of foreign arbitral processes. If the arbitration was being carried out improperly in onshore Dubai, arguably the correct recourse was to the Dubai courts. Thus, the distinction, and therefore the proper limit of the court's powers, is between the exercise of a supervisory jurisdiction, which is properly only for the courts at the seat of the arbitration, and a supportive jurisdiction, which is open to all courts. I would also echo Rupert's comments in relation to the winter-cap jurisdiction, and practitioners in this field should bear in mind the wider developments of the courts in relation to granting awards of interim relief in favour of foreign court proceedings. Therefore, I would agree with Rupert that Deere really isn't the end of the story. The recent trend of decisions is decidedly in favour of the DIFC courts having a power to grant interim remedies in favour of foreign arbitrations. Indeed, there is a real policy question here about how effective the DIFC courts can really be if such powers are not available to them. It's arguable that any mature international commercial court committed to upholding arbitral agreements and processes really ought to be able to award interim relief that assists in meeting those policy objectives. For example, why should the DIFC courts, as a matter of policy, be any less able to prevent a defendant dissipating their assets in an attempt to frustrate enforcement of an arbitral award by way of a freezing injunction than in respect of a judgment? All the more so when that award could ultimately be enforced in the DIFC as a judgment of the DIFC courts without the need for there to be any assets in the DIFC. In my view, the proper limits of the court's intervention can be marshalled by reference to well-known concepts such as supervisory versus supportive jurisdictions or the general international law principles of comity. So that's non-DIFC seated arbitrations. What about arbitrations which are seated in the DIFC? Well, the DIFC courts have shown themselves very willing to grant anti-suit injunctions in favour of arbitration. Thus, in the Hari International case, the Court of First Instance granted an anti-suit injunction to restrain proceedings brought in Pakistan in support of a DIFC arbitration. In our discussions before the seminar, Tom raised an interesting question about the extent to which findings in those sorts of cases can give rise to res judicata in terms of the tribunal's jurisdiction. And there's some interesting case law in England about that, but as far as we're aware, there's nothing yet in the DIFC dealing with that particular question. In another case, in 2014, in Vanin Capital, Justice Al-Mahari granted an injunction requiring monies recovered in a funded litigation to be paid into court. The funding agreement contained a clause requiring arbitration of any disputes under it in the DIFC LCIA Arbitration Centre. The interim order was made under Article 15 of the arbitration law in support of an intended arbitral claim. But I would draw attention to the practical limitations of orders of the DIFC courts. It's like my hobby horse, but the VIH case, I think, is an example of the perhaps Pyrrhic victories that can be found in the DIFC courts. That was, in fact, an injunction in favour of foreign arbitral proceedings. And the background will be well known to most of the participants, I'm sure, in this seminar. Famously, the DIFC court granted an injunction effectively requiring the restoration of the status quo ante pending the arbitration in relation to the management of a hotel on the Palm in onshore Dubai. And there was some quite colourful evidence of the claimant turning up with the injunction, showing it to the police in Dubai, and them sort of standing back and holding their hands up and saying, we've got nothing to do with that. It's a real exam. Ultimately, an application for contempt also failed in that case. So really, it was an example of a great deal of time and money being spent trying to get an injunction in support of arbitration, which ultimately didn't really have any practical benefit or effect for the claimants. So I think one has to sort of put all these issues in the broader picture of enforceability.
Thanks very much, Gregor. Yes, I mean, I think the VIH case was quite specific on its terms, and actually that was a case where the DIFC court's injunction was taken to the Dubai courts, and an order was issued by the Dubai courts, and then there were just simply practical problems with effecting the Dubai court's order within its own jurisdiction. So I think that will always be something that is a risk in those sorts of cases. But Rupert, I wanted to touch on something specific with you. I mean, I think it's Deere again, really, isn't it? Because I mean, we've seen in that case this suggestion that, in a sense, the DIFC court just can't act unless you have a DIFC seated arbitration, and then you've got the progression into Brookfield, where the conclusion appears to be, well, actually the court can act, but you still need some other hook for jurisdiction. So in that case, it was because the claimant DIFC, the defendant DIFC Investments, was a DIFC establishment. So there was a jurisdictional hook already established. And then you've got these more recent cases which suggest that the jurisdiction to grant interim measures could be freestanding, both in relation to non-DIFC litigation, but also arbitration. So I think the question in my mind really is there any way back for DIA on this? Or do you think that the position is really finally settled in relation to that?
Well, I think you're right. I think we had a clear sense that things were moving forward. I mean, it was amusing to watch the DIFC court discover that it had this supportive jurisdiction. Previously, it had been giving interim relief in support of arbitral proceedings pursuant to its supervisory or curial jurisdiction. And then in Brookfield, Justice Cook discovers this supportive jurisdiction. As you say, he makes it dependent on establishing jurisdiction. He makes very clear that it's only in a very unusual or exceptional case, but clearly the door is being nudged open at that point. And one sees particularly when one traces or looks through the anti-suit injunction cases, which is the classic case of the exercise of the supportive jurisdiction as a workaround to DIA, one sees this growing comfort and familiarity with the grant of anti-suit relief pursuant to the supportive jurisdiction of the DIFC courts. And one sees it in FedEx as well, another case where again, a high standard is expected. So it's not just, you don't just have to satisfy American cyanamide as the test in terms of getting injunction. And finally, the dam bursts, if you like, in the case of Hayri and Hazim, where an anti-suit injunction is given, albeit I think in that case to protect a DIFC arbitration. So things seem to be going very much in the right direction in terms of developing the workaround. We've mentioned Winterkamp, which again, possibly erodes the jurisdiction requirement because you don't need to show, you can rely on 51AE jurisdiction by reference to Article 32 of the court law. So again, a strengthening position. But then you get this lurch back, if you like, in that other really significant case last year, the Maidan and Diak decision, where the court declined to make an anti-arbitration injunction and really scuttles back to Article 7.2 and the suggestion there that there's no basis for DIFC court intervention in respect of a Dubai arbitration. So again, that I suspect is a rather worrying step back from my perspective.
Yes, I mean, I think the Maidan and Diak case is another case that I was a part of. I mean, I think it was an unusual case in a number of respects, and I think one has to look at the question of quite how you parse their judgment in that case. I think the judge had arrived at a conclusion that he knew was the correct one in his mind, that the DIFC court oughtn't to be making orders in relation to arbitrations that are ongoing in Dubai but outside the DIFC, to get them to stop, particularly when the supervising institution, DIAC, appeared to think that it could carry on regardless of prior DIFC court decisions. And I think ultimately it might be that case turns to some extent on the application of Article 10 of the arbitration law, which deals with the extent of court supervision, intervention, sorry. And so there'll be a question, is it intervention if you're not going so far as you were in Diak and Maidan and trying actually to stop an arbitration? And also the other part of that is that it only applies in matters governed by this law. And actually, I think that Article 10 is not one of those provisions that is said in Article 7 to extend to non-DIFC arbitration. So there are a number, I think, of avenues that remain available to suggest that that decision doesn't necessarily undermine what has come before, and indeed since, frankly, in the development of the court's jurisdiction to grant freezing orders and other sorts of less invasive orders, if I can put it like that, in support of non-DIFC arbitration.
I mean, Article 10 is essentially a model law provision, isn't it? Which
Correct.
Leads you back to Article 7.2, which is arguably a non-arbitration friendly / non-New York Convention friendly provision. So to the extent it's parasitic on 7.2, does it add much to the argument in your experience?
No, I mean, I wasn't involved in the actual arguing of the anti-suit aspect of the Maidan and Diak case. I was involved in other parts, and I'm not sure that Article 7, Article 10 necessarily featured terribly strongly in the arguments presented by either side. I think it's more of a case of the court finding reasons to support its real solution to this problem, which was that the DIFC court, at least in that case, oughtn't to be trying to stop this particular, at least, non-DIFC arbitration.
I agree with that analysis of that decision. I don't think it necessarily presents a problem, and I think you can reconcile the two decisions, either from a sort of techie point of view, the way I presented it, or you could just say this was a policy decision of the DIFC courts in relation to another sort of quasi-public institution. Why? Yes,
indeed. All right, and then I think, Gregor, if I can hand back to you to pick it up from there.
Finally, I think we thought it'd be helpful just to touch on a couple of the issues that arise in challenging awards and enforcing them in the DIFC. So taking those in turn, challenging an award. Well, the grounds for challenging an award from a DIFC seated arbitration are contained in Article 41 of the arbitration law. They include that the arbitration agreement was invalid under the applicable law, that the applicant was not given proper notice of the arbitration, the award goes beyond the scope of the submission to arbitration, or the composition or procedure of the arbitral tribunal was contrary to the parties' agreement. There is also the helpful or unhelpful, depending on which side of a case you're on, catch-all provision that allows a challenge on the basis of UAE public policy. A perennial issue, which all practitioners will be aware of litigation and arbitration in the DIFC, has been the argument that the signatory of an arbitration agreement was not authorised to do so, often on the basis of onshore UAE law. The Court of First Instance and the Court of Appeal dealt with this issue head-on, and dismissed it comprehensively in the Jeanette case in 2016, albeit from different perspectives. The CFI dealt with the issue by determining first that DIFC law applied to the parties' substantive agreement, because there was a DIFC-LCIA arbitration clause with an express DIFC choice of seat. Once that was established, the judge went on to apply the doctrine of apparent authority contained in Articles 130 and 131 of the DIFC contract law, and found that the signatory had held himself out as having the requisite authority. Therefore, the company, of which he was the director, was bound by the arbitration agreement. In the Court of Appeal, Justice Roger Giles approached the question from a UAE law perspective. He held that what the applicant needed to show was proof that the board did not approve entry into the arbitration agreement as a matter of fact, or the signatory did not have authority. The judge noted that the overall agreement had settled claims requiring the applicant to pay over 900 million dirhams, and he held that it was, quote, likely to the point of near certainty that the settlement agreement was put to the board for consideration, and so too was the arbitration agreement. So a pretty sort of comprehensive demolishing of the argument from both a UAE law perspective and a DIFC law perspective. The point then came up for consideration again late last year by Justice Sir Richard Field in the YYY and ZZZ case. Here, the judge went so far as to say that recognising a Dubai Court of Cassation decision that the signatory lacked authority would itself be contrary to public policy because it would amount to a breach of the New York Convention. What I think comes out from these decisions, and particularly that latter decision, is something that I believe is discussed in the conduit enforcement seminar, is that the concept of UAE public policy under Article 41 and in the DIFC law generally is a nuanced one. It will require consideration in the context of the DIFC specifically and the UAE's wider international obligations. And I think it's quite interesting to see Sir Richard Field reaching for the New York Convention as a way of dealing with these sorts of arguments. And I think the position of the DIFC courts is probably summed up best by Justice Sir Richard Field in the 2016 Gage Investments decision, where he held that the court ought only to find that the subject matter of a dispute is non-arbitrable, where this was being clearly and distinctly demonstrated. That, I think, reflects the generally pro-arbitration tendencies found in English and other common law case law. And I think basically we can safely say that once the jurisdiction of the tribunal has been established, any party is going to face a significant uphill struggle in challenging a DIFC-seated award in the DIFC courts. So turning then to the enforcement of an award. Well, Article 42 of the arbitration law, following the UAE's New York Convention obligation, provides that an arbitral award from any jurisdiction shall be recognised and shall be enforced under the arbitration law unless a ground of challenge is made out. So there is, unless a ground of challenge is made out, there's no discretion. The grounds of challenge are contained in Article 44 and broadly mirror those found in Article 41, which I've just described, including public policy grounds, although there's an additional ground that the award has not yet become binding in the jurisdiction in which it was issued. First, as a reminder, there is no need to show assets within the DIFC for an arbitral award to be recognised and enforced. It is a freestanding jurisdiction, and that was recognised by the Court of Appeal in the 2014 decision in Maiden and Banyan Tree. And in fact, in that case, the DIFC court went as far as to note that the DIFC's asset tracing tools and techniques could prove useful even where there were no assets in the jurisdiction. Secondly, the DIFC courts have demonstrated, again, a robustly pro-arbitration approach to considering defences to recognition and enforcement applications. So in another judgment in the Maidan and Banyan Tree litigation, Justice Al-Mahari referred to the UNCITRAL digestive law on the model law to demonstrate just, quote, how high the public policy defence was to meet. The same judge rejected two defences in the 2014 decision of Fisk, where the defendant had not raised complaints about the tribunal's composition in the arbitration itself, so he held they were stopped from doing so in the DIFC courts. And the judge noted that there was no breach of public policy where enforcement would prevent the defendant from relying on the UAE CPC. It was a matter of public policy, he held, that the CPC did not apply in the DIFC. And in the June 2019 decision of Loralia Group, which was in fact only published last month or in March, Justice Al-Swahili rejected a public policy defence that was based on a ban on contingency fee arrangements in the UAE. He held that whatever the position might be in onshore Dubai, there was no ban in the DIFC, so there could not be, as a matter of public policy, a ban under UAE law as applied in the DIFC. The final option for the recalcitrant award debtor is to apply for an adjournment of enforcement proceedings because there's a challenge to the award ongoing in the seat of arbitration, and that's contained in Article 44, Sub-Article 2. The courts have held in the DIFC that the English test in IPCO Nigeria will apply. This requires that the challenge not simply be a matter of delaying tactics, that the challenge must have a realistic prospect of success, so the summary judgment test, and show due deference to the foreign courts in accordance with comity. As I say, that approach was adopted by Justice Sir David Steele in the Eva and Egan case, who described the threshold question for any court as whether, as a matter of first impression, the award is valid or invalid, so quite a broad brush approach. Subsequent cases have shown a robust approach by the DIFC courts in applying that test, and indeed in preparing for this seminar, I was only able to locate one reported decision where an adjournment was ordered, and that was Fabiola and Fadi in 2015, where there was an ongoing application to the Dubai courts about whether or not the interest awarded was joint or several, as against the award debtors. The court found that was plainly something that needed to be determined before the award could be enforced. So drawing all the strands together, I think the policy rationale here is clear. The DIC courts follow the New York Convention in requiring a balance to be struck between comity and efficient enforcement of awards. And the clear impression from the case law is that very clear and very cogent evidence of the grounds of challenge, as well as the likely delay and prejudice to the enforcing party, will be key in any application.
Thank you very much. That's very interesting. Can I just ask I'm getting a bit of feedback. Yeah. Thank you. I think, I don't know, Rupert, let me ask you this. I find that one of the major problems in this particular area is that after the flurry of early cases that we received after the kind of 2012 conduit cases were pushed through, more recently, we're really struggling to find an awful lot of reported decisions on arbitration in the DIFC court. I mean, I'm personally aware of half a dozen cases, because I've been involved in them, where we've had judgments on some really interesting issues, some of which don't have clear answers in the wider world, and make clear decisions of principle on certain issues that others might be interested in. Is that something that you have found to be a problem in your researches as well?
Well, I think we all, I mean, during in the early days of the conduit jurisdiction, there was a real problem in that many of the judgments were, because they were arbitration cases, were in private and therefore weren't in circulation. There was then a rash of cases, the XX, YY, XX, and YY and ZZ. The courts realised the issue and sort of moved forward. I mean, Tom, when we were discussing this work with Sir Richard Field in London in November, I mean, I think we mentioned to him that the YYY and ZZZ decision hadn't been published, and I think he was quite surprised. I think often you find that judges don't realise that the judgments on which they've worked haven't yet been put up on the website. But I mean, my sense is the court is making strides in terms of trying to ensure that the important judgments, the really important judgments, are anonymised. There's quite a lot of work involved in anonymising judgment, but I think that work's happening. I mean, YY and ZZZ was as Greg mentioned, a critically important case, because one moved on from the sterile debate about, what is Dubai public policy? Does the JAL reflect the policy, or is it in breach of the Dubai public policy? And the old arguments that, actually the JAL is itself a Dubai statute. The old arguments that the exclusion or the disapplication of the CPC is a matter of federal law, so that one can't apply the CPC as public policy of the UAE, precisely because the public policy of the UAE is to disapply and exclude the civil and commercial law of the DIFC. So, and then in YY and ZZZ, you get a return to UAE public. It's said to be DIFC, but it's essentially UAE public policy, and the strong UAE public policy of supporting arbitration and of acting consistently with the New York Convention. Because in that case, it was a very brave finding by Sir Richard Field that the decision of the Dubai Court of Cassation had in fact been contrary to the New York Convention, in that the Dubai courts had applied UAE law. They hadn't applied the law of the arbitration, which was English law. And on that basis, he was not going to recognize it and enforce it as a matter of public policy. So that decision, very important. It was anonymized. It has been published, and it's being considered and discussed now. So
yeah, and I mean it's important in the wider sense as well. I mean, I think I've been in arbitrations where I've had to try to persuade the arbitrators of my position as to whether or not a Dubai court judgment is simply recognised and enforced with all the issues in the DIFC, and drawing on scraps from other cases. And now we have a case which deals with that, and I have actually relied on that and applied it in another subsequent case since. So these sorts of incremental decisions are really important. And you mentioned the YYY case, but also, as I say, I mean, I did a case a couple of years ago now where we went all the way up to the Court of Appeal on a decision in circumstances where my clients had lost an arbitration and the arbitrators had found that there was no arbitration agreement because there was no contract. Could the costs award that they then subsequently issue be enforced anywhere else under the terms of the New York Convention? And the Court of Appeal's answer to that question was no, because the party seeking to enforce was not in a position to say there is an arbitration agreement on the basis of which this award was made. And that actually sounds very simple, but is quite a complicated decision. Has been the subject of quite a lot of academic commentary, but not a lot of international jurisprudence. And I would have thought the decision would be quite interesting to other people, but unfortunately it remains unpublished. I think what I would say is that it's really ultimately, in the way the rules are now currently drafted, it's often left to the parties really to say if they want to have a decision published. So I suppose the message would be to encourage everybody to try to get these anonymized decisions published and ask the court to press forward with that, because I think it is really important, it's critical to the development of the jurisprudence in the jurisdiction.
And Tom, there's a similar issue, isn't there, in respect of the freezing order decisions, which very often are given ex parte, and then as a matter of convention, very often the DIFC court marks them as being in private because they're ex parte. And therefore there's a huge issue as to whether we can refer to them, whether they're and actually when something's ex parte, once everyone's been informed, once the intended respondent has been informed that an application was made and dismissed, there's no reason why that decision shouldn't then be publicised. So perhaps again we need to be a little bit more careful in marking judgments in private where they may not be and where they may be of real value to the wider DIFC legal community. I
agree with that, and I think in particular in the development of the Wintercap jurisdiction that has been the case, certainly. But listen, thank you very much, Gregor. I think we've got some time left just to look at some of the questions that have come in. I'm not sure I've got any more arrived since. So let me ask you this one. Now, Rupert, can you remind me, somebody sent this one in, but the question is, sorry?
I think it's Jonathan Brooks was asking about whether there had been a drop in DIFC arbitration, DIFC seated arbitration since the promulgation of the UAE arbitration law, that's Federal Law 6 of 2018. I mean, and very briefly, if you look at the DIFC LCIA Dubai Arbitration Week report, which is a hugely interesting document, which I can't find on the DIFC LCIA website, so another plea from me in the course of this webinar. But I mean, that suggests a fairly steady rise in DIFC seated arbitration. I mean, obviously I'm using DIFC LCIA arbitrations as a proxy for DIFC seated arbitrations, and that may be unfair. But, you know, if one looks at 2016, only 18, 2017, 48, 2018, 64. So a very steady rise, notwithstanding the UAE arbitration statute. I have my own suspicions that the Meydan and DIAC, the fallout of that case and the publicity of that case may not have been helpful. I think my impression is that DIAC is really working very hard at the moment. It's looking again at the DIAC rules as to how those can be amended and revised. And I think we'll see a resurgence of DIAC, but certainly DIFC seated arbitration is pretty strong at the moment.
Yes, it seems to have been just an ongoing improving success story in recent years, doesn't it? All right.
Okay, and I am now going to take over as quizmaster. The question at this stage for Gregor, the question asked by Peter Smith. Are there any interesting points of comparison between the DIFC arbitration law and the English Arbitration Act of 1996?
Well, thank you, Peter, for the question. Obviously, the starting point is that the arbitration law is based on the Unstrong model law, whereas the English Arbitration Act is famously very much not based on that model law. I think one of the two particular examples jump out. The first is in relation to interim measures and Article 24(3), which I discussed. And the equivalent provision is Section 44 of the 1996 Act. And the jurisdiction for the English court to intervene with interim measures is far more restricted by that section than under Article 24(3). So unless the application is urgent, and by that the Act really means orders for the preservation of assets, freezers, that kind of thing, the court will only act if the application is made with the permission of the tribunal. And even when the tribunal gives permission, the court, and I quote, shall act only if and to the extent that the arbitral tribunal has no power or is unable for the time being to act effectively. So Article 24(3), however, has no such limitations at all. So there is a risk, one might say, of parties in the DIFC heading off to court far more readily and with far more ease than they could do in England. Perhaps one way of sort of explaining it is that when the Arbitration Act was introduced in 1996 in England, arbitration in England was pretty mature. It had a long history. Therefore, there was probably felt to be less need for court intervention than when, for example, the arbitration law was introduced and the arbitral jurisdiction of the DIFC was more nascent. It may have felt that there was more need for the ability for the supervisory court to intervene or to assist in the development of that jurisdiction. Whether or not that's still maintainable now is a different question. And of course, the other main distinction between the English Arbitration Act and the arbitration law is that in England you can appeal on points of law. You have an absolute right to appeal on points of law. And in our discussions for this, Tom rightly pointed out that is seen by practitioners as one of the stumbling blocks preventing London really developing and picking up as an arbitration centre, because it's seen as a mechanism for the court to intervene in matters that really ought to be left to the arbitral tribunal.
Yes, I mean, I wouldn't necessarily say that I think it's a bad thing that appeals can be launched on law in England. I think, though, there is a perception amongst parts of the arbitration community that the English law goes too far in allowing court intervention in that way, because that means the judges are deciding issues on the merits, which to some international parts of the international community ought to be left to the arbitrators. So yeah, that was the issue there.
The trouble with the DIFC arbitration law is it's sort of living contradiction, isn't it? On the one hand, it wants to be model law compliant, but on the other hand, for example, not being able to stay proceedings in breach of arbitration provisions, whether it's a foreign-seated arbitration, and not being able to extend interim relief in support of foreign arbitrations, all of those clearly raise real issues in terms of the New York Convention. And you have that, exactly as you said, Greg, you have that contradiction with Article 24(3), which says, you should be able to, the court should do what it can do in support of court proceedings, regardless of the place of the arbitration. But then at the same time, within Article 7(2), that provision isn't given effect in respect of non-DFC seated arbitration. So at the heart of it, you have this, as I described it, timidity. Gradually, that timidity is being removed. But it's very hard to sort of pin down the DIFC arbitration law. Clearly, it's now becoming clearer through the jurisprudence. But if one looks at the statute, it's very hard to place it very precisely.
And I think that comes out in the point you made earlier on about the interaction between Articles 7 and 10. What 10 actually adds to 7 isn't entirely clear. There's also an interesting question about the interaction between Article 15 and Article 24. Article 15 is extended to non-DIFC arbitrations and basically declares that the court is able to grant interim measures. But it's Article 24 which grants the power, and it takes away that power by saying it's only for DIFC seated arbitration. So it sort of gives with one hand and takes with the other.
But could I just add a personal point, which is if you're rather one of those lazy people like me who accesses DIFC statutes by Googling DIFC arbitration law, if you do that, you actually get the old arbitration law, not the amended arbitration law.
Careful.
So you need to make sure you're quite careful in your searching for the statute. Last question is from Ahmed Hamadi. I'm going to ask this one to Tom. If you're in a case where there's a DIFC seat, UAE parties, and an issue as to jurisdiction, should you seek a declaration as to jurisdiction from the DIFC court, or should you leave it to the tribunal?
I think this is a really interesting question, actually, and it's a similar issue has arisen in a case that I was involved in. I think strictly the answer is that the issue of the validity of the arbitration agreement is, on the English approach, the fee only trust approach, likely to be an issue which is covered by the arbitration agreement. So it should be an issue to be decided by arbitrators. But actually, this issue arises quite often in the context of an anti-suit injunction. And so what happens is one party is denying the existence of the arbitration agreement, the other party is saying it does exist. And so the denying party goes off to another forum and starts proceedings. And that prompts an anti-suit application in the DIFC court or the court at the seat. And if that application is ultimately put in terms of a claim for final relief, final injunctive relief, then the respondent to that is put in quite a difficult position, because what they can't do is say, well, under Article 13, you have to stay these proceedings in favour of arbitration, because they're denying the existence of the arbitration agreement. And so in those circumstances, you can get to, and in the Hayri case, we did get to, a final injunction, which is based on a finding of the validity and applicability of the arbitration agreement that underlies it. And then the next question is, well, is that then binding on the tribunal? And in that case, it was found to be binding on the tribunal. They said it was res judicata, it had been decided, and they couldn't go back to it. And the issue there was not so much, is there a binding arbitration agreement? By the time we got back to the arbitration, they had finally conceded that point. The issue in that case was whether it was DIFC or Dubai, and the tribunal said we're not going to have to get into that. So I think that the issue does arise, and it depends in part on how you put your claim. So you have to be quite careful, both how you put it and how you respond to it. It does arise when you're applying for anti-suit injunctions. Would I apply for a declaration? I think that obviously a declaration is a discretionary remedy, and there may be other issues that have applied. And in fact, that was one of the remedies that we sought in the Hayri case. Would you apply for it on its own? Well, I think then you potentially might have this issue. But then I suppose the other party might dispute jurisdiction on other grounds to say, for example, there's no underlying jurisdiction aside from the arbitration agreement. So you may end up finding yourself in dealing with a bit of complexity, which leads then to doubt as to whether or not the decision follows through in the arbitration. But I think it's a really interesting question, and definitely one that needs to be considered in each case. All right, well, look, I think we're out of time. So all that leaves me to do is to say thank you very much again for coming along today. And do try and catch the other seminars if you didn't see them before. Thank you to Gregor, both for his input on the chapter and also for his preparation for today. It's very much appreciated. Do please try and join us for our next seminar. That one there'll be a slight hiatus, and we'll be back on the 16th of June, same time, so 3 p.m. Dubai, 11 a.m. London. And in that seminar, we will be looking at some of the recent developments in substantive law within the DIFC.
It's 2 p.m. Sorry.
I beg your pardon?
2 p.m. Dubai.
Sorry, you're absolutely right. 2 p.m. Dubai. Sorry. Thank you, Rupert. 2 p.m. Dubai, 11 a.m. London. I was working on GMT. So thank you again. Thanks to Rupert, and thanks to Shanna and her team for helping to put this together. And we'll see you next time, I hope. Goodbye.
Thanks.
Take care.